Haley says on behalf of the people.
Before the courtroom even gets fully underway, the tension in this case is already thick. What you're about to watch isn't just another routine hearing. It's a courtroom moment where a judge begins pulling apart a story that doesn't quite add up. The case centers around a defendant accused of a violent confrontation involving a firearm, allegations that someone was struck multiple times with a gun, and a situation where a victim reportedly feared for her life while a child was present. And that's already serious territory. When firearms enter the picture in domestic or interpersonal disputes, courts immediately shift into high-risk evaluation mode. Judges start asking a different set of questions. Is the victim safe? Is the defendant likely to reoffend? Is the person actually respecting court orders? But here's where the drama begins to build. The defendant claims medical issues and hospitalization prevented him from appearing in court. The prosecution, however, is pointing out something much more troubling: a long period of time where the defendant allegedly failed to show up at all. That gap in accountability is about to become the central issue of this hearing. And if you're new to courtroom proceedings like this, here's something important to understand. Failing to appear in court can often make things worse than the original charges themselves. Judges see it as a sign of disrespect toward the legal process. And that can dramatically change how bail or bond decisions are made. So as this hearing unfolds, pay close attention to the timeline. When did the defendant appear? When did he disappear? And why did it take so long for him to end up back in front of this judge?
Thank you. What are we doing? Go ahead.
Your Honor, at this time, the people will be requesting the defense bond be modified to the original 100,000 cash surety passed at arraignment. This defendant failed to appear at 2023 and exam and proper witness. He was also out on probation for had stopped and picked up 2 felony charges, I believe. And I believe in this case, he was released on May 7th, and it showed on, actually still has a warrant for a BOP, other non-support warrants. And the people believe that in this case, the bond would be appropriate at 100,000 given the serious nature and concern for the victim's safety. In this case, the victim and defendant come in, the defendant was at the residence with their daughter. The victim picked her up. The argument began while they were arguing. The defendant pulled the gun from his waist, cocked the gun as if to look around, pointed it at the victim and also at their car that their child was in. The victim was in fear for her life, and he struck her with the gun 3 times and then fled.
That detail right there is extremely significant. When prosecutors mention that a victim was struck with a firearm, the legal seriousness escalates immediately. Even if the gun was never fired, using a firearm as a weapon, what courts sometimes call pistol whipping, can qualify as aggravated assault or felonious assault depending on the jurisdiction and circumstances. And notice another key detail the prosecutor included: the child being present in the vehicle. That changes the emotional and legal weight of the situation dramatically. When violence occurs in front of a child, courts often interpret that as an aggravating factor. It signals not just potential physical harm, but also psychological trauma to a minor who witnessed the incident. The prosecutor is doing something very deliberate here. They're not just listing facts, they're painting a risk picture for the judge. Every detail about swelling on the victim's head, cuts near the ear, and visible injuries is meant to show that the alleged violence wasn't minor. They're building the argument that this defendant could pose a continuing danger.
When the officers talked to the victim, she had noticeable swelling above her left temple, cut above her ear, and blood on her shirt. We were also concerned given the defendant's past history of assaultive and domestic violence charges, as well as dismissed domestic violence charges. So maybe asking the bond set at 100,000.
Response. How did he come into custody?
Your Honor, I was in Detroit.
Okay. How'd you get into custody? Did you walk in or were you picked up?
I was picked up in Detroit.
Mr. Allen.
A case out there. And then I handled all the case. I came out here. I got discharged off of probation. I had to stay in Washington County for about 7 years. So when this came in,
Your Honor, he was picked up originally, but I think that this second attempt at bond increase, the second bite at the apple, he was released. He's coming to court today. He's ready to.
But hold it. While he was out, basically absconding on this case, my understanding is he picked up other cases?
This is the moment where the judge starts signaling concern. And if you've watched enough courtroom proceedings, you know this tone shift matters. When a judge starts referencing additional cases or new charges, it's a warning sign for the defense. In bail hearings, judges don't just look at the current charge. They examine the defendant's overall behavior pattern. Are there other pending cases? Are there probation violations? Are there additional warrants? Every new piece of legal trouble makes it harder for the court to trust that someone will follow the rules if they're released again. The judge here is essentially asking, if this defendant was already dealing with one serious case, why did new cases appear while he was still out? That raises red flags about accountability and decision-making. And here's something many viewers may not realize. Bond decisions often hinge on two primary risks. Risk of flight, meaning the defendant might disappear before trial, and risk to the community, meaning the defendant might commit additional crimes. When the judge mentions new cases while the defendant was already out, he's evaluating both of those risks at the same time.
As the people's understanding, while he was on probation for aggravated stalking, the judge slaves court.
Those are support cases, if I'm correct. Good.
Or it might be on 14. But our notes had that he had a video hearing on 5/2, the judge said.
The initial was a failure to appear when we were before the thing. I did that arraignment for him. And there were 2 months of time where he was in the hospital, if I recall, and he suffered some burns as the court made clear.
Hold on a second. Because back, just looking for a date on this, I don't know that the defendant just didn't come into court. He was incarcerated in Wayne County, January of this year. And then proceeded to send us information for a plea by mail. Requesting a trial date, review of bond with a request for dismissal due to the hearsay clause, and Washtenaw County has no jurisdiction over me. Because he's a permanent resident of Wayne County. Yeah, go ahead.
At the arraignment, we were going back and forth with our magistrate Pink and I, and she said, I won't quote her exactly, but the summary of it was, let him out on bond because some of it was confusion. He should be holding himself to the same standard as an attorney, but this was kind of an attempt at self-representation. And so as you can see, he's here now with an attorney. He's coming into court to address these charges, to address everything that's happening. He's not a flight risk judge. He's here now, so I would say that.
He's not a flight risk? Where was he?
He was in the hospital for 2 months, Your Honor.
When?
The court date in question, I remember it was April 4th. And he was in the hospital at that time.
Now, your assistant prosecuting attorney, Morgan Barroso, and have the people looking back at our notes, what we see is that this is the 2022 case. He was set for exam pro se on March 7th. The victim was present, willing, and cooperative. The defendant appeared on Zoom. The court, they tried to proceed with the exam at that date, but the defendant had insurmountable technical difficulties, so it was adjourned out to April 4th. And on April 4th, the defendant didn't show up.
Did not.
Did not show up. He failed to appear, and he was put in bench warrant status.
Now we reach the turning point of this hearing. Failure to appear in court is something judges take extremely seriously, sometimes even more seriously than the underlying charge. Why? Because the entire justice system relies on defendants actually showing up when they are required to. According to the prosecutor, the timeline here raises serious questions. The defendant appeared on Zoom once, had technical issues, the hearing was rescheduled, and then when the new date came around, he simply didn't show up. That triggered a bench warrant. A bench warrant is essentially the court saying, we gave you a chance to appear voluntarily, and now law enforcement has the authority to arrest you and bring you in. It's one of the most common ways defendants end up back in custody. But here's the part the prosecutor is emphasizing. The defendant didn't turn himself in after missing court. Instead, he allegedly remained out for nearly a year until he was eventually located while already in custody somewhere else. And that's exactly the kind of timeline judges scrutinize. Because from the court's perspective, someone who doesn't resolve a warrant quickly is someone who may ignore future court orders as well.
After that, on the 11th of April 11th of 2024, over a year later, he's in custody in Wayne County and mails in the misdemeanor plea by mail to the court.
Correct.
So he's in bench warrant status for over a year. And obviously there's something else, other context with law enforcement going on because he's in custody in Wayne County during that time while in bench warrant status. I'm sympathetic to him being in the hospital for a couple of months in there, but that doesn't explain the other 10 months plus where he was in bench warrant status and failed to turn himself in. At this point, I think that there's an issue with his bond being where it is and with him being out of custody, at least without having a GPS.
Well, but he didn't appear for a preliminary examination.
Correct.
This lawyer informed me that I have a case in Washington County for a different reason. So at that same time, my lawyer told me to call down here, get on video camera. I was doing everything on video camera from the hospital. I saw you one time on the camera. So
It wasn't my preliminary examination.
yes, examination because I was in the hospital, so technical reason.
Oh, no. So then, after you missed the preliminary examination, what took you so long to turn yourself in? Well, you didn't turn yourself in, you got picked up.
It's like Magistrate Garwood says all the time. I tell this to my clients. I said, look, if your cell phone bill goes out, if cable goes out, you're gonna pick up the phone, you're gonna call that and get that resolved immediately. And
I don't know if quoting Magistrate Garwood is convincing to me.
but what I'm saying is, Your Honor, I explained this to him. He wasn't represented before. He didn't understand. He tried to represent himself.
Oh, I think he understood. He understood the date. He's giving me his excuse that he's in the hospital, and then we don't see him for 10 months.
This is one of those moments where the judge's skepticism becomes very clear. The defense is arguing confusion, saying the defendant tried to represent himself and didn't fully understand the process. But the judge is pushing back on that explanation. Self-representation in court is allowed, but it's also risky. When defendants act as their own attorney, the court still expects them to follow the same rules as licensed lawyers. Deadlines don't change. Court appearances are still mandatory, and misunderstandings rarely excuse missed hearings. The judge is essentially saying, you knew the date, you gave the hospital explanation, but that only accounts for a small portion of the time. What about the other 10 months? That question cuts right to the credibility issue. Judges evaluate whether explanations sound reasonable when placed next to the full timeline of events. If there are long gaps that don't make sense, it weakens the defense argument. And remember, credibility matters enormously in bond decisions. A judge must decide whether they believe a defendant will return to court if released again. If the explanation feels incomplete, the judge may assume the safest course is keeping the defendant in custody or raising the bond amount significantly. So at this point in the hearing, the tone has shifted from explanation to accountability. and the judge is clearly signaling that patience is running out.
And I don't know why a bond was set when we finally get to him in the amount that it's set at. In my opinion, that's a clear abuse of discretion. He didn't appear for 2 court proceedings. Well, appeared at 1. He wasn't, I don't think, supposed to be appearing via Zoom. I think Judge Perry did the best she could and then couldn't proceed with that. And then he was supposed to appear, didn't appear, and then disappears. And I think has committed other offenses, because what was he locked up in Wayne County for?
It was a obstruction of justice, and I took care of that case. I came back here, I got dismissed off probation. Judge bear with me because I lost my lyrics, I lost my whole day. So I had to get my body together. And then I promise her, I'll come back and take care of this because I need to get this time. I lost my whole day, as you can see.
I understand that. I'm glad it's worked for you. All I'm saying is you haven't appeared at these proceedings. You didn't turn yourself in. You got picked up. And that's the only reason that you're here. Otherwise, we would probably not be seeing you. As I've said, I think it's an abuse of discretion that this bond was set as it was. Your bond now will be $50,000 cash surety, defendant's remanded.
And there it is, the decision. The judge has officially raised the bond to $50,000 cash surety, which is a major shift from what the defense was hoping for. For viewers unfamiliar with bond terminology, cash surety means the defendant must post the money, either personally or through a bondsman, to secure release. It's essentially a financial guarantee that the defendant will return to court. If the defendant fails to appear again, that money can be forfeited. Why did the judge increase it? Look at the reasoning we just heard throughout the hearing. Allegations of violence with a firearm, a victim who feared for her life, a missed preliminary examination, a bench warrant, and a long period where the defendant didn't turn himself in voluntarily. Each of those factors stacks together to form what judges call a risk profile. The higher the perceived risk, the higher the bond tends to be. The judge also made something else clear. The defendant wasn't brought here because he voluntarily resolved the situation. He was picked up. That detail weighed heavily in the court's decision. Now here's something interesting for viewers to consider. Some people argue higher bonds ensure accountability. Others believe they unfairly keep defendants in jail before they've even been convicted. Where do you stand on that debate? Should bond be used primarily to guarantee court appearances, or should it also reflect the seriousness of the alleged crime?
Oh. Did I send it to you? I did not. I'll set the probable cause out. I'll just set it out since I took him into custody. I'll set it out next week, May 16th, 2024, 9 a.m. Court does call the case People versus Yusuf Cyrus. Who is this? Who? Far out? Oh, here. Hang on. Ooh, bring it back. Yeah. Step back a second, sir. I'm sorry. Court does call the case of People versus Mohammed Farah. Okay, what are we doing? Discovery's complete. Of course you would. Discovery is complete. People had their witnesses available the 21st. Preliminary examination will be set May 21st, 2024, 9 a.m. That is before Judge Valvo. As to bond.
Thank you. Regarding bond, the department does have another matter. Your ownership bond is $2,625. He tells me that he intends and they post that if he's granted a PR on this case.
Did he post it?
No, he doesn't intend to. If this Court is inclined to grant him a personal bond in this matter. He does have state.
So we get into a chicken or the egg, because I'm not moving it if he's got another bond.
And other cases of CCW use.
Thank you.
That's correct, Your Honor. Would it be more appropriate to raise that preliminary examination after he posts the bond in the other matters?
I would think so. Judge Valvo would be more than happy to hear it.
Thank you.
At this time, motion for bond reduction is denied. Bond will continue. Thank you.
That short statement might sound simple, but legally it's very significant. The defense just attempted to reduce the bond, and the judge rejected it outright. In bond hearings, defense attorneys often argue that their client deserves release because they have jobs, family ties, or stable housing. Those factors can sometimes convince a judge that the defendant isn't a flight risk. But prosecutors counter with something different: the seriousness of the alleged crime and the defendant's past behavior. Here, the judge appears to be siding with caution. When a court denies a bond reduction, it essentially means the judge believes the current bond amount is appropriate given the circumstances. In other words, the court is not convinced that lowering it would protect the public or guarantee the defendant returns to court. It's also worth noting that bond decisions often send signals to both sides of a case. A strict bond can indicate that the court views the allegations seriously. It can also influence how defense attorneys approach negotiations or plea discussions later. For viewers watching at home, this raises a big question. Should bond decisions focus mainly on the seriousness of the alleged crime? Or should they prioritize a defendant's ability to maintain work and family responsibilities while awaiting trial? Because in cases like this, those two priorities can collide, and judges are forced to decide which risk matters more.
Clerk recalls case Peter versus Yusuf Cyrus. Thank you.
Your Honor, we're just asking for a 3-week adjournment to submit mitigation information to here at Barroso for consideration.
May 30th, 2024, 9 a.m. without objection. Bond continued. Thank you. Court calls case People versus David Davis.
Good morning, Your Honor. Judge Overwater, this is public defender on behalf of Mr. Davis. Approaching. Mr. Davis, would you state your name for the record? Mr. Davis.
What are we doing?
And we worked out a plea agreement. Plea form was sent to the court last night.
A plea form that indicates he's going to plead to attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 are dismissed. That's the court's entire understanding of the agreement.
Correct. Yes, sir.
Let's have him sworn.
You sound swear to fire testimony about the truth and all the truth of God.
Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that?
As the judge begins explaining this plea agreement, it's a good opportunity to break down what's happening here legally. Plea deals are one of the most common outcomes in the criminal justice system. In fact, the overwhelming majority of criminal cases never go to trial. They end through negotiated pleas exactly like this one. The judge is carefully walking the defendant through the rights he's giving up, and this is extremely important. When someone pleads guilty, they waive several constitutional rights: the right to a trial, the right to confront witnesses, and the right to challenge the evidence against them. Courts must confirm on the record that the defendant understands those consequences. You'll also notice the judge asking whether anyone threatened or promised anything outside the agreement. That's another safeguard designed to ensure the plea is voluntary. If a defendant claims later that they were pressured into pleading guilty, the court record showing these questions becomes critical evidence. What we're seeing here is the court ensuring that the plea is legally sound before accepting it. Once the judge accepts it, the case shifts towards sentencing rather than trial. For many defendants, a plea like this represents a strategic decision, accepting a lesser charge now to avoid the risk of a much harsher penalty later. And that calculation happens in courtrooms across the country every single day.
All right. You understand also, sir, that if I that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in 14A2 District Court. All right. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will. And because you believe that you are indeed guilty of this offense? On the date of February 29, 2024, at the location of Buckingham Drive near Hamlet Drive, Superior Township, Washtenaw County, State of Michigan, did you come into contact with Washtenaw County Sheriff's deputies? What happened? How'd that work? Yeah. You kind of came out of the garage. Yeah. You have no dispute they were giving you a lawful command to come out of the garage, do you? You're not disputing that it was a lawful command they were giving you to come out of the garage. You just didn't come out. Well, not. But you eventually came out. Yeah. Counsel, if I complied with the court rule, would it be proper to accept this defendant's plea?
Defense is satisfied, thank you.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be when? July 9th, 2024. What time? Doesn't matter. 10 a.m. Before Judge Barr. Bond continue.
Thank you, Your Honor.
60 days. It's 2 months. Okay? Emily, I'm just counting. I don't know. Court calls case People versus Wayne Franklin. Your name, sir. Thank you. What are we doing?
We're going to set this matter for preliminary examination. I would ask the court also to consider a bond.
Discovery complete on both cases. People have their witnesses available the 21st. Preliminary examination will be set in person, May 21st, 2024, 9 a.m. before Judge Valvo. That's the bond.
Your Honor, it's my understanding that the complaining witness in this matter is likely left the state. She does not reside with my client. He has his own place that he'd be staying at. My client has 2 jobs. He works for a cleaning service called Arrow Cleaning, where he works nights. He also works at AF John, where he's a property manager for various strip malls.
Here we see the defense presenting a classic argument for release: stability and community ties. The attorney is emphasizing that the defendant has 2 jobs, family support, and responsibilities at home. These factors are commonly used to convince judges that someone is unlikely to flee if released. Personal recognizance, often called a PR bond, is essentially release based on trust. Instead of paying money, the defendant promises to return to court and follow conditions set by the judge. Courts sometimes grant PR bonds when they believe the defendant poses minimal risk to the community and has strong connections that encourage them to comply with the law. But notice how carefully the attorney frames the argument. He's highlighting the defendant's employment, family responsibilities, and the financial hardship that continued incarceration might cause. Those points are meant to humanize the defendant and shift the judge's focus from the alleged crime to the broader impact of detention. However, prosecutors often counter these arguments by pointing to violations of court orders or repeated behavior patterns. If the prosecution can show that the defendant previously ignored legal restrictions, judges become much less likely to grant a PR bond. So now the courtroom is about to weigh two competing narratives: a working provider who supports his family versus a defendant accused of repeatedly ignoring court orders.
He indicated he resides on Alpine Drive. His mother also lives locally. He has her support. I'd ask the court to consider releasing Mr. Franklin. Personal recognizance bonds. You have to comply with the tether requirements that court felt that if they were necessary. The allegations in these cases are not particularly aggravating. There's been, to my knowledge, no indication that he's had any contact with complaining witness since he's been incarcerated. So I would ask the court would be willing to consider his release today. He has reported to me that he is the only provider for his family. His wife does not work, and if he continues to be incarcerated, he will lose his role with his jobs.
I first want to note out the gate that he has bonds denied out of 15th District Court, and that is not up until May 15th. But on the attempted home invasion case between April 7th and April 11th, the defendant assaulted and stole the victim's iPhone. The defendant was released on a PR bond on April 19th. It was prohibited from having contact with the victim or going to the residence. On April 24th, he told the victim that he was allowed to have visitation with the children and came to the residence. The victim, after that, then called the court and learned that what the defendant told her was a lie. The defendant has repeatedly harassed and texted and called the victim, resulting in aggravated stalking charges in the case 24F55094.
This portion of the hearing introduces one of the most serious issues courts deal with in domestic-related cases: violations of no-contact orders. When a judge issues a no-contact order, it's a direct legal command that the defendant must not communicate with or approach the alleged victim. Violating that order can result in additional criminal charges, which appears to be exactly what the prosecutor is describing here. The prosecution is outlining a pattern: alleged harassment, repeated messages, and even an appearance at the victim's residence despite a restriction against doing so. Each of those allegations strengthens the argument that the defendant may not respect court-imposed boundaries. And from the court's perspective, that's critical. Bond conditions and protective orders only work if defendants follow them. When someone allegedly ignores those restrictions, judges often respond by tightening custody conditions rather than relaxing them. Another interesting element here is the prosecutor referencing a specific text message. Even a single message can become key evidence in stalking or harassment cases, especially when it occurs after a clear no-contact directive from the court. This moment also highlights a broader legal theme. Once someone is under court supervision, their actions are scrutinized much more closely. Behavior that might otherwise seem minor, like sending a message, can suddenly carry major legal consequences.
In the attempted home invasion, he violated the no-contact order, founded on the defendant's work, or founded on the victim's work, causing damage to the security. And it was so loud that it caused neighbors to take notice and filmed the defendant leaving the scene. I also want to note that as far as his contact with the victim, he did text her, he contacted her multiple times, resulting in aggravated stalking charges. But one of note which gave us concern is on April 26th, saying, "I don't know if I can ever forgive you. God is going to really have to help me through this time." He violated a no contact order, lied to the victim about what he was allowed to do, and appeared at her residence in violation of no contact. So it wasn't even just virtual or verbal violations. At this point, I would object. I also want to note that we had requested $100,000 on each of these files. On the attempted home invasion, we were only given a $5,000 bond, and on the aggravated stalking, we were only given a $15,000 bond. I'm not asking for an increase today, but I do think any reduction in those already small nominal bonds would be inappropriate at this time.
Your Honor, the text message that was cited by the state is the only alleged contact that he had that makes up the stalking that's a violation of any kind of bond condition. As far as the home invasion is concerned, the only allegation that suggests that he was even involved is the statement of the complaining witness. The alleged damage to the door, according to the report, indicates that the deadbolt was not broken, but the chain was. So the only way that he could have done that would have been to bend the door so far in that it broke the chain, but the deadbolt held. There's no damage to the door, which doesn't actually make any sense.
Motion for bond reduction denied.
Thank you.
And with that final ruling, the judge closes the door on the defense's attempt to reduce the defendant's bond. After hearing arguments from both sides, the defense emphasizing employment and family support, and the prosecution highlighting alleged violations and continued contact with the victim, the court ultimately decides that the current bond conditions should remain in place. This outcome reflects a common judicial priority: maintaining safety and ensuring compliance with court orders. When allegations involve stalking, harassment, or violations of protective orders, judges often err on the side of caution. Even if the defendant has community ties, the court may decide that the risk of further contact with the victim outweighs those considerations. Cases like this illustrate how the justice system tries to balance competing concerns. On one side is the presumption of innocence, the principle that a defendant has not yet been convicted. On the other side is the responsibility to protect alleged victims and maintain the integrity of court orders. As the proceedings move forward toward preliminary examinations and potential trials, the evidence presented in those hearings will determine what happens next for the defendants involved. If you found this courtroom breakdown insightful, make sure to hit that like button, share your thoughts in the comments about how the judge handled these bond decisions, and subscribe for more in-depth courtroom analysis and real case breakdowns.